Good morning. Welcome, everyone. We're going to wait about 1 minute while all of our participants get logged on, and then we're going to go ahead and get started. Welcome, welcome. All right, I can see people logging on. Okay, we've got a good number of people here. So we're going to go ahead and get started at this time. Thank you for coming to our webinar today. Today's webinar is on how to sell real estate post-death. I'm Stacy Grow. I'm the Director of Marketing and Client Experience at the law offices of Daniel A. Hunt. And we're excited to be hosting this webinar today. If you've missed our previous ones, recordings are available on our YouTube channel. You can just go to YouTube and search Law Offices of Daniel Hunt. We currently have over 70 educational videos posted there, so you might be interested in checking that out. All available for free. I'm also going to be sending out a PDF of our slides from today's presentation, along with a link to the recording once it's ready. So let's go ahead and go over a few housekeeping items. Okay. So I think most people have probably attended some Zoom meetings, a few Zoom meetings by this point. But if you are new or you haven't been to one in a while, if you're on a computer, you can move your mouse down to the bottom of the screen to view your controls. On the bottom left is your audio. You'll also see a chat box where you can communicate with the host. And there's also a Q&A box where you can type your questions as we go through the presentation. We will be having a brief Q&A session at the end, but you can ask a question at any time. Feel free to do that. We anticipate that our webinar should last around an hour with a few minutes at the end for the Q&A session. If you have a question that's very specific to your personal circumstances, we're also going to be sharing contact information at the end, so you can reach out to either of our speakers for personalized advice. Okay, so with that, I'm going to go ahead and introduce our two speakers today. Daniel A. Hunt is the owner of the law offices of Daniel A. Hunt. He is a certified specialist in estate planning, trust, and probate law. And he has over 10 years of experience dealing with real estate sales and trust and estate matters. We're also very excited to welcome Betty Brody with us today. She is a certified probate real estate specialist, as well as a senior real estate specialist at Coldwell Banker. She has over 17 years of experience selling Sacramento area homes and is a lifetime member of the Masters Club, Sacramento Association of Realtors. So we're really excited. We've worked with Betty for many, many years, and we're excited to collaborate today on this presentation. So with that, I'm going to go ahead and turn the time over to Dan.
Thank you so much to our wonderful host, Stacy. I'm going to have her, before the slides go out, I'm going to have her update it. I have way over 10 years of experience in dealing with real estate sales. I'm just going to say that. I have way more than that. I think that's since I've owned the firm is 10 years. But Stacy, you got to give me more credit than that. I was dealing with real estate sales and trust and estates well before that. So
fair enough, fair enough.
But I'm not offended. I'm okay with that. I'm comfortable with my experience in it. And really, thank you, Betty, for coming and joining us. Betty and I worked for years together. On her handling, obviously, the real estate side of the transaction and us handling the trust or the probate transaction of administering it. So I do have to start with a story, because it's incredible how even professionals, it seems like they do not know how a real estate transaction actually works. I was pacing around my office yesterday afternoon, scratching my head, almost pulling my hair out because I was dealing with an opposing counsel on a case. And if my client is listening today, she'll probably know which case I'm talking about. This is a very large estate, many pieces of real property. It's almost a $20 million estate. My client wants to buy one of the pieces of real property, but wants to make sure that she's getting it for what the market value is. So the idea was that she'd have like a first right of refusal to purchase it, but to market it, to have a realtor go out and market it, see what offers they get. She as a beneficiary can look at the offers and then say, okay, I want to beat that one, or I don't. I think that I don't want to pay that much, and here, take that offer because you're going to get a bunch of money for it, and wonderful, that means more money in my pocket. And this attorney, who is, he's been practicing, it seems like forever, did not understand. He's like, why would a realtor ever want to list that property if they knew there was a first right of refusal on it? And I would ask Betty, if you were guaranteed a sale with a first right of refusal on a property that was, valued at $1.7 million, would you want to list that property, Betty?
I would not turn it down.
That's smart. That's smart. Would not turn down that listing. So it was crazy because he thought that, like, because there was a first right of refusal, that the realtor evidently wouldn't get a commission if it ended up being my client that purchased the property. So anyway, it was fascinating to me that an attorney who I'm going off of his bar number, has been practicing for probably 30 years, didn't understand even the very basics of a real property transaction and how realtors work, why they would want to work, how they even get paid. I was kind of fascinated by that. So if you're out there, dear client of mine, which I won't mention by name, I'm working on it. We're making headway with that guy, but we're working on it. But maybe he's listening today and he's going to learn some things. So we're going to start off today talking about who you are, Betty, a little bit about your background and why somebody would want to use a realtor in selling real property after somebody passes, or even, quite frankly, if they're incapacitated, if they're a fiduciary, either executor, administrator, or trustee, how that works. So tell us about that. Tell us about your probate certification, Betty, what that even means for a realtor.
Okay. Well, every real estate agent has to pass a state exam, California state exam, and any real estate agent can help a client out with a probate property or a trust property. However, there is more involved with these type of transactions. There's a lot more involved. So what I did was to learn more about it. I just took some additional educational classes that required, passing an exam, and it allows me to specialize in this part of real estate. So I have been an agent for about 17, almost 18 years. So of course I do, regular real estate, just straight sales with sellers. But I absolutely love working with trust and probate clients. It seems to work best for me. I understand the process. And with every phase that goes into it, the attorney is involved. And there is different paperwork involved and different steps of the transaction that makes it different. So you really need to know what you're doing in real estate. You can't just hire anybody. I mean, you can, but a lot of times it becomes very complicated unless you're working with somebody who has experience working with the attorneys and working with the probate and trust process.
Right. So, for example, somebody passes away and one of the kids who's might be named executor in the will, they can't just show up and sign a listing agreement with you, correct? If they're just named as the executor, they've got to go get their letters first. So there's a process that they've got to follow. If they sign a listing agreement with you as an individual, but they're really selling it from the estate, that's going to cause problems down the road with the contract where they're going to try and close escrow. And then, oh my gosh, we don't have letters from the court. This closing is not going to happen. And then you've probably got a pretty ticked off buyer and a pretty ticked off seller at that point. Things like
Yeah,
that.
absolutely.
Okay.
Yeah.
Good. And then you want to talk about the rest of these also? Senior real estate specialist. What does that mean?
The senior real estate specialist, it could be a little misleading with that title. It might mean that, you know, I'm at the top of the food chain being a senior, but technically it refers to elderly, working with elderly people. In this niche of real estate, I do work with a lot of elderly people and their families. So it just allows me to understand the process working with the elderly people a little bit better.
All right, very good. Wonderful. Anything else on this slide you want to talk about?
I think we covered it.
Okay, let's go on to the next one there, Stacy. Oh, sorry. Why should I use a realtor to sell real estate post-death? So, and when we want to talk about that, to protect yourself against legal liability. So this is a good idea to use a real estate agent, because how that protects you from liability. If you go out as an individual, you're the fiduciary, the administrator of the estate, the executor of the estate, which we remember from previous webinars. Administrators are when there's no will, executors are when there is a will, but you've been appointed by the court and you're administering somebody's estate, or the trustee. You have a duty to maximize the value of that property, to sell it if you're going to sell it, but to maximize that value and sell it for the benefit of the beneficiaries. And so if you go out and just sell it to somebody who walks down the street and makes an offer and you're like, that's a pretty good deal, the beneficiaries, they can come back and say, what did you even do to market it? Well, somebody walked by, they really liked the property and they made an offer and I accepted it. And a beneficiary will say, well, how do you know that the next person walking by the street wasn't going to offer you $50,000 more or $100,000 more or $1 million more? We don't know that, but when you hire a realtor, obviously that is good at their job. They're going to market it well to as many people as possible, so that as many people as possible have an opportunity to present an offer, and then you as the fiduciary have to take the best offer. And we can even talk about that, because Betty, maybe you can answer this. Is the highest priced offer always the best offer?
No.
Okay,
no.
Tell us why.
Well, you know, there's a lot involved in a real estate transaction, and even, you know, outside of trust and probate, especially in a seller's market where we are right now in Sacramento County, Placer County, and pretty much California. So I see offers that come in way over asking, and there's a lot involved with coming in with an over asking offer. That particular buyer has to back up the financials and the money that they're offering to come in and in an over asking offer. They have to show that they have the money. They have to be financially secure with a lender. There is contingencies involved that a lot of times a strong offer would be to remove some of those, and not so much coming in with the amount over asking or even at asking. It has to match the appraised value. So a lot of times it looks really good on paper, but it's not real until I do some research and call the lender and check out the financial part of the transaction, which is, you know, huge. You know, if
Right.
we don't want anything falling out of escrow. So once we get a solid offer, I typically go through, you know, making some phone calls and making sure it's legitimate and it's the strongest offer. So it doesn't mean that it's always the highest offer.
Right. So you may be sitting there as a fiduciary and think, okay, I'm gonna sell this property, and you get an offer for $500,000, and they say, you know, we're gonna put 20% down. We're not gonna have any contingencies. We want a 30-day close. And then another offer comes in, I'll pay $550, but it's contingent on me selling my 30 acres of bare land in the Mojave Desert, and I'm going to put $100 down, so that if I'm not able to close on that, I just lose my $100 deposit, right? So in that case, you'd be looking at it saying, okay, which is the stronger offer here? Which one should I be going with? It might very well be that lower one, because the likelihood of the contingencies being removed on the higher offer is next to nothing, and then those buyers are going to walk and go find a different property, and now you're sitting there with nothing, and now the beneficiaries are going to be ticked off if you've lost a really good buyer. Now they have to sit there and wait longer to get their money, or they just plain lost money. So it protects you from legal liability, because then you are saying, I relied on a professional to go out and get the highest and best offer for this property. Okay, and this is how they marketed it. This is, we marketed it for 2 months, 3 months, 4 months, and we took 10 offers that came in, and this is the best one that we took. And then a beneficiary, it's going to cut them off from being able to try and remove that fiduciary for breaching their fiduciary duties to them. So, okay, let's go with the next slide now. Here we have two very sad young ladies that are dealing with what looks like maybe what an estate sale is. So let's talk about that. Standard sales versus estate sales. What is the difference between those? Can you start us off with that, Betty?
Well, estate sales usually require a clean out and sometimes a cleanup. A lot of times I see these properties and they are quite distressed. I've been doing this for a little while, so I'm able to walk into a property. I'm not really affected too much by messes and hoarder houses and different things that could happen. As an individual gets older, they tend to collect a lot of things. If there's a spouse that has passed away, there's even more things collected. So, walking into an estate property that needs to be sold, there's a lot that I do going into it. I love a good transformation. I love to go in and figure out, what can I do to get the most money for this house? And just because it's an estate property doesn't mean that, we could just put it up for sale, put a sign in the yard, advertise it on the MLS and sell it. I like to maximize the value of the property by handling a lot of the cleanup and the clean out and taking things to charity and doing several things to get the property ready. And I'll have it staged. We'll do professional photos, we'll do videos. And so what I like to do is just to handle the whole process with, the mindset of getting the most money out of the house.
I imagine you being like one of those HGTV shows, walking and saying, this has a lot of potential. It's got good bones. Let's maximize the value here.
Yeah.
Okay, fair enough. So we're also talking about different documentation that's required. I know that there's like things like that are called like probate advisory forms. That's basically advising everybody that, hey, this property is going through probate. And so here are some of the differences between, going through probate and just a normal sale, things like that. Also, do you want to talk about really kind of the grief versus the excitement that you're dealing with as in a real property transaction?
Yeah, it is different. Like I said, I've been doing this for a little while, so it's different, taking a regular listing and then an estate listing. I would say 90% of the time, there is grief involved. There's other family members involved. There's a level of consideration that needs to happen for that. So whenever I do meet with the client, I have that in the forefront of my mind that they have just lost a loved one. And there is a level of emotion that goes into selling the property. A lot of times it's a family home. It's a place where maybe they grew up in, or maybe it's not, but it belonged to their parents or a loved one, and they have to go through items. They have to, bring up emotional things that just happen when they're getting ready to sell a property. So I take that into consideration versus a regular sale where I will meet with somebody and there's a level of excitement and it's exciting to get the house ready and exciting to market it and get it staged and keep in touch with them the whole time and keeping them excited. But this is a little bit different. again, we're dealing with somebody who has just lost a family member or a loved one, and it definitely is a more emotional. There's an emotional component involved with these transactions.
For sure. And what I noticed on our end, difference between somebody who's selling their own house, like a normal real estate transaction of we're outside the context of somebody's passed away and we're selling their home. Difference between that and that we are selling mom or dad's house after they've passed away is with that emotional grief. Many times the realtor does a good job because the son or daughter, they're so, or even spouse, but not as often that we're selling a spouse's home, but the son or daughter is so emotionally burdened that they're like, just do whatever, sell it for whatever. I don't really care. Just get it sold. And so that would lend itself to maybe not maximizing the value for that property when really that's their duty to do that for these other beneficiaries that are there. They really have to do that. So it's important for the realtor to remember that and make sure that, hey, we know that you just don't even want to deal with this, and I'm going to deal with this for you, but we still do need to follow our duties. Whereas somebody where it's like their house and they think that it's worth 2 times as much as it actually is, and you as the realtor kind of have to bring them down, and they get ticked off because essentially you tell them, it's like telling them that their baby is ugly, their own house, that nobody's going to pay for that.
Right.
And so you got to bring them back down to earth. Whereas in these estate sales, many times it's you got to kind of bring them up maybe and be like, hey, we can't just take the first offer that walks through the door because you don't want to deal with this. We've got to do what's best for the beneficiaries or the heirs here. Okay, good. And now you're going to tell us what your job is during the actual transaction.
Okay. So a lot of times when I meet estate clients, again, they're in a state of grief, but what I find most all the time is a sense of overwhelmment. So I will meet them at the property that needs to be sold. And again, a lot of times there is some distress to the house. Most of the time it's full of furniture and items and things that have collected throughout the years. And it causes a level of stress for the loved one because they don't know what to do. They don't know where to start. They just are in a state of just kind of feeling a little chaotic and overwhelmed. So what I like to do is to relieve all of that and to, make it as smooth as possible, considering that they have lost someone. Part of the services I offer is to do the cleanup. I have the client go through the items with their loved ones, take everything out of the house that they want, and then they just give me the keys and I handle everything else of getting it cleaned out, cleaned up, charity runs, and I will invest in staging and, marketing, and again, trying to maximize the value of the house. There are times where, properties are too distressed, too much is needed structurally. And a lot of times, the client will want to just sell it off market. And I think we're going to be talking about that in a few slides. Okay,
nuts and bolts though. Somebody passes away and you say, okay, I first thing I do is I meet the potential, executor, trustee, whatever, at the property. Nuts and bolts. How long are we talking about from time of death to when you're meeting them at the property? Is there a standard time? Is there just kind of whenever? Like, is it a week, 2 weeks, a month, 6 months, or is it just kind of up to them?
It's up to them. I try to find out what their goals are, what their time frame is, how they would like for things to, as far as the timing of it, what's important to them. A lot of times they have to wait for family members to go through items with them. But most of the time, when I do meet with the client, they're pretty much wanting to, move on, get it over with and get it sold. So I usually take about, up to 2 weeks to 3 weeks, depending on how much needs to be done with the property. I took a listing last week and I have it ready to go by the weekend. So it all depends. It all depends on what's needed. And once I do take the listing, I have a crew that I work with, and I call this a well-oiled machine, and we get things handled quickly. You know, we do, you know, base the purchase price or the list price on comparable market sales. So maximizing the value is always, you know, a goal of mine, but keeping in mind that, you know, somebody has lost someone and dealing with grief and things like that, it usually comes together pretty quickly within 30 days from the time I list it.
Yeah. Okay. So we are talking about that later, where it's like from the time they meet, maybe 2-3 weeks to get that property ready for showtime. I did see a question pop up, which was great. Somebody said, "Hey, don't you have to sell that sucker within 6 months? Otherwise, taxes start going wild and all that good stuff." And the answer is no. You don't have to sell it within 6 months, but when it comes to notifying the county assessor of a change in ownership, yes, you have to do that. I think the county assessor, they want notification within, I think it's like 45 days, if I remember correctly, where you have to notify the county assessor, hey, there's been a change in ownership. And so it's going from deceased to then you notify them as to who's going to be receiving which children. And it used to be in California that we had our wonderful parent-to-child exclusion for property taxes, so that if parent, you know, bought their house in 1970 for $100,000 or $50,000, and their property taxes are based off of that, and now parent dies in 2021, and guess what the kid got to do? Keep the same property tax basis. So you'd notify the assessor, and the assessor would get mad if you didn't notify them fast enough, and then they would automatically reassess the property when they got that affidavit of death showing that, okay, somebody's passed away. They'd reassess it to whatever the full value is at that time if you hadn't notified them. So those forms, yes, there is a limit on sending those forms in. But now also our parent-to-child exclusion has been snatched away by the legislature, but we do get the benefit that now once you're over 55, you can pretty much take your basis with you wherever you go in California, which is kind of cool. So hopefully that answers that. But also the other reason why they would not be able to mandate you have to sell it within 6 months is Betty, because she's been doing this for a really long time. She's experienced slow markets. So what if you can't sell that property within 6 months? There's things like that happen. It hasn't been like that as of late. Obviously, as of late, you put it on the market, and then at 10 o'clock and then at 11 o'clock, you have 20 offers and you're ready to go. It's so that not an issue as of late. But so hopefully that answered that question. There's notices that have to go out to the county assessor, but as for when the property has to close, like it has to be sold, there's no limit on that. Really, the limit that's placed on that is really the beneficiaries. If a trustee's not doing their job or executor's not doing their job and they're not selling the property, they're sitting on the rear end, it's the beneficiaries who can show up and say, if you don't start doing your job and get this property sold, I'm going to sue you, and I'm going to remove you, and I'm going to seek damages against you. That's what happens when it comes to the time frame for selling a property. If they're not doing their job, then they can get kicked out and get sued for damages. Okay, that was a lot of talking. I'm sorry. I get so excited about this stuff. All right. Marketing the property. This is another great slide for you to take, because as people come in, I tell them I am not a realtor. I do not know how to market a property. We're going way too fast, Stacy. We got to slow down. We need a little more time. Are we short on time? Is that Stacy giving us the hint to hurry it up? We're at 10:30. We're doing fine. Okay. So all right, marketing the property. Tell us what goes into that, Betty.
Okay. Well, it's funny, as you said, I'm not a realtor. I don't know how to market a property. And I'm kind of laughed to myself because I think a lot of realtors don't know how to market a property. I happen to feel that it's a very important piece of the transaction, and it's a very important piece, you know, maximizing the value and also getting a quick sale. I keep, you know, talking about maximizing the value, but I also would like to say that I try to get it done within a certain amount of time. To where it's not sitting on the market. And how I do that is I do whatever I can before it hits the market to make sure that it, the market has been, kind of ethered up. So what I do is I get the house cleaned up, cleaned out. A lot of times I will do staging unless the property is very distressed. Then sometimes, it's an off-market sale. So we do videos, professional photos, professional staging. It goes into the MLS, which is the Metro List System in California, which is the nucleus of everything us realtors do. And then it will be on the internet, Trulia, Redfin, realtor.com, all of the websites. It'll be blasted on the internet. And because we are such an internet-based society, and everything it goes back to the internet. So back in the day, somebody would pick up the phone and just call a real estate agent and say, hey, I want to buy a house. Nowadays, they go online and they're going to look at pictures and they're going to look at videos. So what I try to do is to get the property to look as good as it can, because people are going to be looking online. So that's what I do as far as marketing.
Listing a property, is it an art or is it a science?
It's a little bit of both. Everybody works differently. I like to do everything up front so that there's no surprises in the middle or at the end. A lot of times I do like to get inspections up front again, so there's no surprises. Most of the time, the probate and trust properties are sold as is. So selling an as-is property, a lot of times the buyer needs to know, what is as is, what's the condition of the property. So I encourage getting inspections up front to create a more smooth transaction once we get into contract on the property.
So that would be the science side of it, as I understand, where there's just certain things, the boxes that you have to check and inspections that you need to get.
Correct.
But then as for deciding on a number, that's more of the art side, I presume.
Well, it all depends on the market and what's happening in the market, where you live, what county, what zip code, researching the property and getting it priced correctly up front is extremely important if you want your house to sell quickly. And I don't think anybody wants their house to sit for a long time, but you have to be realistic on the pricing, and it has to match the comparable market sales. And having said that, doing an as-is property, getting inspections up front, oftentimes I will make a recommendation of pricing your property at a certain number that the inspections, that it reflects on the work that needs to be done.
Okay.
Just pricing it realistically is really all you have to do.
Yeah. And having worked with now probably thousands of beneficiaries, answering this question, when do they want their money? Yesterday or the day before or last week is essentially what the answer always is going to be. Yes, Robin, we're going to get to listing agreements. Don't you fret. So that you have to balance that, where a trustee or an executor is going to come and say, hey, we need to get this property sold like now. But you can't do a fire sale. You have to find that balance between maximizing value, but so you can't just list it super high and be like, hey, I've got to maximize value, because otherwise I'm going to get sued as the trustee. But if you list it too high, literally nobody is interested in it, and it sits there for months and months and months. Now the beneficiaries are going to get ticked off at you because the property hasn't sold. They don't have their money. So finding, and a good realtor obviously is going to understand the balance between those fiduciary duties of getting the beneficiaries their money like they want, because they always want it yesterday, and also getting it maximize the value so that you don't have a beneficiary ticked off that you didn't sell it for enough, that you sold it for a fire sale and you did a terrible job. Okay, so before we get to listing agreements, we had also their open houses, yes or no. So as an executor, if they're like, okay, should I be expecting my realtor to do open houses? And if they're not, is it a bad job? Or if they are, is it a waste of time and money? Like what's going on with open houses? You want to talk about that?
Well, open houses are a little interesting right now because of, needing to be COVID compliant. And then last year, we weren't even allowed to do open houses. In my opinion, open houses can be great. Is it necessary? It all depends on where we are in the market. When I list a property now, I put, time and effort into the property to get it what I call list ready. And if in this market we're in right now, you get a house list ready and it looks good online, and it's priced correctly, most of the time it's going to sell fairly quickly without really needing an open house. An open house, it does give you exposure, but the most exposure you have for any listing it is the internet, is the MLS. So open houses are good for local exposure, but what's really going to sell your house is the marketing and the internet and a qualified buyer, obviously.
Okay, good, because I know that in my neighborhood where it's like open houses, it's literally just an opportunity for your neighbors to walk through the house and say, I've walked by this house a ton of times. I just kind of want to see what it's like on the inside. That's it. But really, those who are interested, they're going to see online, that's the house that I want. Here's the pictures, and they're going to make an offer. They're going to basically contact you, the listing agent, and say, I want to walk through this house. Let's do it. Something like that. But the real information is happening kind of on the internet, and that's where it's going to be at. It's kind of like I kind of use the same analogy where it used to be everybody wanted to come and meet their attorney in person, and it's like, okay, I got to look them in the eye and make sure that that's the right attorney. Whereas now, especially with COVID, has set this up. It's like nobody wants to come see me in person. They look us up online or they do their research and like, okay, this person knows what they're talking about. And then they call us up and tell us their legal issue, and we handle it that way. But the equivalent of we have to hold our doors open and let everybody come in and stare and gawk at us to be hired, not really super necessary when you have the internet that's kind of the information hub there. Okay, let's talk about listing agreements. What the heck are they? What's in a typical agreement? What kind of provisions or clauses can they be expecting as an executor, as a trustee, when it comes to signing a listing agreement?
A listing agreement is a contract between the real estate company. So for example, I work for Coldwell Banker. So it would be a contract between Coldwell Banker, me acting as the agent, and the client. Typically, I will put the date of, a 6-month listing. I haven't had a house sitting in 6 months, I think forever. But we typically do a 3 to 6 month listing. And what is on that listing is the agreement that you are, hiring Coldwell Banker to sell the property. It also has on there, an agreement of agreed upon commission, which I'm a standard fee. And it also has on there the name of the person who is the administrator, the executor or trustee. And also it gives permission for me to do the marketing on the internet, put a sign in the yard. So basically it's an agreement between both parties to sell the property, and it will have a certain price and a time frame on it.
Okay, so it talks about your here we go, Robin. She's like, tell me, what's that typical fee? We're gonna nail her down, aren't we? All right, so you want to talk about that, because it's the same thing with lawyers, where it's like they just want to know, how much do you cost? What's typical for that? And when it comes to lawyers, I tell them, you get what you pay for.
It's the same thing with real estate or anybody that's, a commission-based real estate agent. I typically charge a standard fee of 6%, but I also handle quite a bit more than I do on a regular listing with an estate listing. There's a lot more steps involved. And so, taking on a lot of extra projects, but I do have a crew, like I said, a clean out crew and a cleanup crew, and getting a plan of action rather than just putting a sign in the yard. And you certainly could hire somebody to just put a sign in the yard and do very limited marketing and save some money, but you're going to, again, maximize the value by working with somebody that has a level of experience that knows exactly what to do to maximize the value.
Sure. And I mean, yeah, as the old saying goes, you get what you pay for. Everybody knows Dan Hunt. And I typically don't speak in third person. I just hated myself hearing it. Dan Hunt, he's not the cheapest lawyer. I'm not the cheapest lawyer in town, right? That's somebody else. You're going to go and you can find attorneys that will have a lower hourly rate or lower flat rate if they're doing estate planning and things like that. But you're going to get what you pay for, right? Yeah. So in many cases, other times it's just there's people that are off the charts on what they charge, and you're not getting good value. But you really got to look at that and ask around. Does Betty know what she's doing and selling houses? Get good referrals, all that kind of stuff. So, all right, good question. I know there were some others coming in. Let's make sure we get through all the material. We'll actually probably come back to those. There was one about getting out of contracts, and we'll talk about that in the Q&A. Okay. This one, finally, one for me. All right, fiduciary responsibilities. So, as the fiduciary, and I've been talking about this kind of the whole time, because really this is the thing that will trip up an executor or trustee, is if they're not maximizing the value of that property. That's the big one. That the beneficiaries, two reasons they get ticked off when it comes to real property transactions. Really three. One, they say that dang executor didn't sell this property for enough. We think that they undersold it. That's number one, that they get ticked off for that. So how do you avoid that? Obviously, hiring a realtor and marketing the property is the number one way to avoid that. Okay. And also beyond that, being very transparent with the beneficiaries, saying, here's all the offers I got. Bad fiduciaries will not do that. They will go and sign a contract without even showing the other beneficiaries other offers that came in. They just accept one and they say, deal with it. But showing the beneficiary, saying, here's all the offers that I got. This is all, laying it out on the table. And they may have their opinions as to which one to take and all that good stuff. But I will say this, the buck stops with the trustee or the executor. If you've got disagreement, or if you think it's not in the best interest of the beneficiaries to take one offer that they said you should, really you can overrule them, because that's your job as trustee and executor to say, here's what we're going to do. And then after you've made your bed, you get to sleep in it. That's how it really works being a fiduciary. Kind of a thankless job, but you were the one who was asked by the decedent to take care of this estate. So getting the most value, number one complaint. Okay. Number two, that you took too long. So that they're sitting there and they're not selling the property. Well, obviously, how do you get around that? You sell the property. Okay. Do it in a timely manner. Really, when we're talking about what's normal, it is not normal to have mom or dad still cold in the ground to be meeting with the realtor after the funeral luncheon. It's not normal, right? That's a little odd. But a week, 2, 3, it's within a month for sure to be starting that meeting with the realtor and getting this thing listed. That would be more norm. But waiting months to even list the property is not normal. That's where you're going to have beneficiaries that are going to be ticked off as to, why are you not doing your job? And then the third reason that I think executor or beneficiaries will get upset is they want to buy the property and you're not going to sell it to them. That's the third reason. That happens where beneficiaries are going to say, I want to buy the property, and you're not going to do it for whatever reason. And there are valid reasons, and then there are invalid reasons. Honestly, the valid reasons are beneficiaries are looking to be treated better than someone else. So if a beneficiary walks up and says, yeah, I want to buy the property, you're like, that's wonderful. What's the market rate for it? I can't give you a special deal. As the trustee, as the executor, you have a fiduciary duty to all of the beneficiaries. So you can't be giving them a special deal. That's popping up. Is that on my screen or yours, Stacy? I think that's on yours. Can we X out of that? There we go. Up. Hopefully the mouse. Anyway, we're gonna X out of that. So you can't favor them. Are you there, Stacy?
Yeah, there's nothing on my screen. I think it might
Oh,
be.
it's on my screen then?
Yeah.
X out. Okay, it was on my screen. Sorry, everybody. I apologize. It's all the reminders of the appointments I have later today. Okay, thank you. So you can't favor them. You got to say, okay, we got to figure out the market. So if that's getting an appraisal, which we talk about, then yes, we go get an appraisal. Here's what it appraised for, and then we can sell it for that appraisal price, or very, very close to it. You know, maybe a little below, maybe a little above, but right there. But you can't favor them. And then, but yeah, invalid reasons are, it's just like, oh, you know, I don't want to sell it to you. I have to market the property and get the highest price. Well, let's get an appraisal. We'll figure out what the market property or what it's worth, and then go from there. So that's really kind of an art there. The science behind it, you know, you can't favor a beneficiary and give them some sweetheart deal on the real property to the detriment of the other ones. So many times that's what they expect, but you can't do that. So how do you minimize the risk, the executor trustee? Listen to your lawyer and listen to your realtor, is what I would say. When you are relying on the advice of professionals, that is going to minimize your risk, because we have done this many times. I literally, there's a client, and if they're on there, she probably knows I'm frustrated with her, where I said, you've got to sell this property and you've got to distribute this to the beneficiaries. And drag the feet. I said, you're going to get sued if you don't sell the property and distribute it. You're going to get sued. Drag the feet. And then guess what showed up yesterday? A lawsuit because she didn't listen to me. So always listen to your the professionals that are advising you, and that's going to minimize your risk. And then Betty, do you want to talk about, oh my gosh, we only have 12 minutes left. Betty, do you want to take like 10 seconds, 15 seconds to talk about appraisals, why to get them or why not to get them?
Appraisals, getting it up front may or may not be necessary. A lot of times with these properties, if they are distressed, and I would insist on getting an appraisal, because it's hard for me to put a legitimate number on it. And also, if you get into the middle of escrow, if you have a buyer who is going to be obtaining a loan for, you know, to purchase the property, they are going to get an appraisal from their lender anyway. So doing one up front, a lot of times I would say it's not necessary if I can establish a list price by with the information that I have. If it's a property where it's hard to put a number on, then I would recommend getting an appraisal, so that you know that you're getting legitimate offers that match what the value of the property is.
Good. And on the lawyer side, because all we want to do is protect people's liability from getting sued. On the lawyer side, we generally tell our clients who are selling the properties from the estate, it's generally a good idea to spend the $350 and get an appraisal, so that you know what the value is there,
Yeah.
and the beneficiaries aren't going to get upset. Okay, next slide, Stacy. We'll probably take maybe a minute or two, and Betty can tell us about selling properties off market, what that means.
Okay, so when I do meet with a client, an estate client, there is an option to sell off market. Sometimes the person, the administrator, or the family members would like for it to be sold very quickly. And if they can be sold off market in quickly, that's when I would recommend getting an appraisal, because I work with a handful of investors and they're pretty legit, but they will come in and lowball. So we need to get it as close to that appraised value as possible. And it can be a good thing. It's quick, it's fast. Usually they pay cash and money's in the bank within 7 to 10 days. Most of the time in the market we're in right now, I try to market the property to get more money. If having, extra money isn't that big of a deal, or if it's not as important as getting it buttoned up and closed and you're fine with what is being offered by the cash investor, then that's also a good thing too. So it all depends on what your goal is.
Yeah, and on the lawyer side, where the problems would come up. As it says there, disadvantage to it, possible claim of breach of fiduciary duty. If you got some rascally beneficiaries who already have it out for you as an executor or trustee, I would be telling them, don't be selling this property off market. Go out there and market this. Make sure you get a bunch of offers, and then you choose the best one, even showing all the offers to the beneficiaries. Would not recommend it. But if you have a situation where it's like all the beneficiaries, close-knit family, siblings, and they're like, yeah, let's just take this one. Like Fred from down the street, we all know he's been wanting to buy this property forever. We got an appraisal. It looks like it's right in line with what it's valued at. We don't need to market this thing. Please, trustee or executor, just do it quick this way. Do it off market. That situation, wonderful. But the one where you got rascally little beneficiaries who want to sue you already, wouldn't do that. All right. And then obviously we talked about when you market it, you can possibly get a higher price, especially in today's market. Okay, time frame for selling a home. What are we looking at?
From the time an offer is accepted, I would say 21 to 30 days. It depends on how the buyer is purchasing the property. How are they financing it? Even some buyers who aren't investors, sometimes they pay cash. So if that's the case, then it's a shorter time frame. But typical time frames 21 to 30 days if they are obtaining a loan.
Right. All the folks who sold their house in the Bay Area, come over here, drop down their cash on the Sacramento real estate. Exactly. Yeah. Okay. And then escrow, I think we're going to talk about escrow on the next one as well. But as you said, typically between 21 and 30 days. So what is escrow? Escrow are the wonderful folks who make sure that all the I's are dotted and the T's are crossed. They sit there and they hold the title of the house hostage until the contract has been fulfilled, like all the money is in and all the inspections have been done, and that they go through and make sure that title is clear. So they're, like I said, they're the ones who are holding title to the house and the money of the buyer. And then once the contract is fulfilled, then they go ahead and exchange it. That's your escrow. I remember as a kid, my dad, he was in real estate, and he would, we'd like to know, because I grew up poor, we'd like to know when we're going to eat again, Dad. And he'd say, oh, when escrow closes. And I had no idea as a kid what the heck escrow was, but I knew that it meant that my dad got money when it closed. That's what it meant. So obviously after the contract is fulfilled, the escrow, the title officers, they do their title search to make sure that obviously clean title is being given over to the buyer, and all the contract provisions fulfilled. Now, after that closes, okay, so title gets handed over to the buyer and money gets handed over to the seller, the executive administrator. What happens there? Well, that money is going to be deposited into the trust account or into the administration account, the estate account. And then it's going to sit there, obviously, until it's ready to be distributed. And how that works, obviously, in probate, it doesn't work where you sell the house and then the executor just takes the money and distributes it to the heirs. That's not how it works. You have to then, once everything is, all the taxes have been paid and all the other expenses that have been paid in the estate, that's when you can go and petition the court and say, hey, court, we are ready to distribute. This estate is in a position to be distributed. And once the court has that hearing and anybody has an opportunity to show up and object to it, nobody objects, everything's cleared out, then the judge gives the order and says, okay, executor, now you can distribute. And they have their little order that's signed and said, executor, give the money out in this way. And that's when the checks get written to the heirs at that point. But it's not typically when escrow closes. And a trust administration, much, much quicker. You don't have to wait for court. Money goes into the trust account. If the trustee looks at everything and says, okay, all the bills have been paid, taxes are paid, we're kind of in a good situation here, it looks like everything's good, they can start writing checks and distributing out to the heirs. All right. Next slide, Stacey. Oh, good. 5 minutes left. We timed it very well. I'm impressed. 5 minutes left, and we said 5 minutes for Q&A. Here we are. All right.
All right. So we're going to do some Q&A at this time. If you have a question, go ahead and type it into your box. We do have several that have been asked. So I'll go ahead and ask them, and then whoever wants to take the question can speak up. So John had a question about the letters that Dan had referred to. So does a trustee of a living trust need letters from a court to sell real property?
No, they don't. What do they need? They need a certification of trust that says, I certify that I am the trustee of this trust. That's what they need. So they don't need letters issued by a court. And who drafts the certification of trust? An attorney typically does that. If you want to try it on your own, be my guest. But who knows if it'll be correct? But you'll want to get the certification of trust drafted by the attorney that certifies, here's who the trustee is. This is their authority to act on behalf of this trust and direct the realtor to do whatever they do, title, all that good stuff. So no letters issued by a court when it comes to a trustee.
Okay, so next, Susan had a question about if a property is in a trust, what is required legally when it comes to selling that property?
So if a property is in a trust, what's required legally to sell it? Once again, I mean, obviously you have to follow the trust provisions. So if there's special provisions in the trust that say so-and-so can live in the property for a year, okay. Or so-and-so has a first right of refusal. If they want to buy the property, they get first crack at it. You got to follow that. But if there's nothing like that, if it just says, hey, distribute it equally to my children, then what does the trustee do? The trustee will get put in the seat of being the trustee, right? Where they accept their role, they accept their responsibility, all that kind of stuff. They sign that certification of trust. It says, I'm now the trustee and I accept all the rights and responsibility that comes with it. And then they go and they sign a listing agreement with Betty, and then they're off to the races with what we've all described for the last 54 minutes.
Okay, great. So next, Karen wants to know about the transfer of a home to another family member, like a great granddaughter. What's involved in that process?
So to put it simply, if it were the great granddaughter, if she just wanted to buy it, then she'd be treated like anybody else. But if they say, oh no, great granddaughter is a beneficiary and we want to transfer it to her as part of her distributive share, then we'd be talking about just getting an appraisal so we know how much it was that we're giving to her. So we're going to account for it. And then you'd be doing a letter, a deed. A letter probably the beneficiary is letting them know what's going on, but a deed that says trustee is distributing this to great granddaughter so and so. Here's the property description, and now the property is hers. So, and the forms that go along with that, you obviously are going to notify the assessor. It's going to get reassessed, and the county recorder. Deed goes on that, but then property's hers. That's how that works.
Okay. All right, next question. The owner passes away and there's two beneficiaries, but one doesn't want the house. How does the other one buy them out?
It depends. If they get along, great, get an appraisal and then buy them out, whether it be with funds from the trust or estate, or whether they go to their bank and get the money and buy them out. They have the big hiccup is agreeing on a price. And other families that don't get along well, what do? Everybody hires a lawyer and they fight over the price, and they go to mediation, or they go to and have a trial, and they spend way more money than what the difference was in that. But honestly, it's the process there is typically, it would be getting an appraisal saying and agreeing upon a price. And then one of them says, okay, I'm going to take this property for X amount of dollars. The other beneficiary says, okay, a deed is drafted. It goes now into the title that beneficiary wanted it, and the money is exchanged. And really, there's no need to open escrow. All that stuff would be handled by the attorney's office.
Okay, great. And then Robin had a few other questions that we didn't get to previously. If things aren't working out, how do you get out of a listing agreement?
You want to take that one, Betty?
Every agent handles that a little bit differently.
He's like, you can't. You're handcuffed to it.
Yeah. Personally speaking, for me,
yeah.
I've only had a couple of cancellations. I mean, my goal is to make sure everybody stays happy. But in the event it's not working out for whatever reason, there is a cancellation, that can be signed, a cancellation form within the office. But, Coldwell Banker would send you a cancellation form, and I would be, again, it depends on the agent. If somebody doesn't want to work with me, then that's fine. Go ahead and sign it and move on. I'd hate for that to happen, but it's as simple as signing a cancellation form.
Yeah, and if you had a different agent that's like, no way, you can't list this with anybody else because you signed this for 6 months. That's just like any
Yeah.
contract. You look at the contract provisions, say you didn't do this, and then I'm out of here,
Yeah,
and then
yeah.
go sign a new listing
Yeah.
agreement.
Yeah, sometimes you can be
Whatever.
obligated to pay a certain portion of commission whenever the house does sell.
Right.
I don't know too many agents that really stick to that. But it's basically just signing a cancellation agreement and, you know, and dealing with any ramifications of commissions when the house sells. You may have to, you know, agree to pay the original realtor a certain amount once it closes.
Okay, great. So I'm just going to do 2 more quick questions, and there are some more in-depth questions being asked. The last slide, we're going to have contact information. So if you have really specific questions or more in-depth questions, feel free to reach out to our speakers. They'll be happy to get back to you. So first quick question before we close, does selling a house with furniture help or hinder the sale?
Hopefully this doesn't sound rude, but it all
Depends
depends
on the furniture.
It all depends. Like, I mean, is it from 1978 or is it, you know, I typically like to move everything out of the property and hire a stager that knows what they're doing. So it depends. It depends.
Okay. And then last quick question, does the realtor fee cover inspections, deep cleaning, appraisals, all of those other costs?
The realtor fee, and I didn't say this earlier, but it's important that some people don't know that that fee also pays, typically another agent is going to represent the buyer. So that fee is split between both companies. I pay for the house cleaning, I pay for the staging. As far as any inspections, I have the seller pay for the inspections.
Okay.
So it sounds like it's all kind of negotiable.
Yeah,
So
it
not
is
all listings
Sure.
here. Okay, fair enough. And I'll
Okay.
say this, well, this is coming up. Those other questions, go through, do your thing, Stacy, about contacts and all that kind of stuff. But honestly, those of you gotta go. Those of you who had the questions, stay on. I'll get them answered. We'll do that.
Okay. Yeah, I was just going to say, so if you have more in-depth questions, feel free to reach out to our law firm. We always offer a no-cost initial consultation. And also feel free to contact Betty. All of her contact information is here. You can also Google her. She has a great website. And I'll be sending a PDF of these slides that will also have that contact information. So then I'll turn the time back over to you, Dan, if you want to answer these last few questions.
Those of you who got to go, thank you so much for coming. And then Stacy, can you do you have those there? You read those off to me and then you can answer
Yeah,
those.
sure. Okay, so question on what Betty does that is worth an extra 1% when there are other real estate agents who only charge 5%. I think you've kind of already touched on that, but if you want to just recap.
Yeah. So
Go ahead, Dan.
I think it was for me. She's like, what? Oh, maybe. It's like, okay, why do I refer people to Betty? Maybe that's a good thing. Because Betty, everybody knows what you're going to say, Betty. You're better than everybody else, right? They know that. No, but honestly, why I feel comfortable where it's like, okay, referred to Betty is honestly because of the experience. And I know that she's going to get the highest price, obviously, because you might save that 1%. Oh, great, wonderful. We saved 1%. But then you're losing $100,000 on a property that wasn't marketed correctly. It's obvious that 1% is not going to be. It's a loss, right? If you're trying to go save 1% with a realtor that's terrible. Then the other thing is also even just doing the stinking forms correctly. That was the other thing that was frustrating to me when I deal with these realtors who've never been through this before, and then we're looking at the forms that have been drafted. It's like this is all done wrong, okay? And so now we're having to spend attorney time, which I can tell you right now, attorney time, you all know that's not cheap. We're spending attorney time to correct the things that the realtor is doing. So when it's cutting into obviously that it's just making it more expensive. So having a realtor, you're getting what you pay for, just like with an attorney, that a good one is going to do the job correctly to maximize how much is going to go into your pocket. That's why I think it is. And so, but once again, it's executors, they get to pick whoever they want. So you're going to want to pick the person that's obviously going to find the balance between selling it quickly, maximizing the profit. And that's why a realtor would say, I'm worth it because I'm going to get more money in your pocket than some Joe Blow is going to take 5%, stick a sign up in the front yard, and then screw everything up, lose a transaction, and be a mess. And you're going to want to tear your hair out at the end. That's why I would say using somebody who knows what they're doing is probably worth that extra 1%. Anything to add to that, Betty? Okay.
Well said.
I think I got it.
Okay, perfect. Next question is, why would a family member want to sign a rental contract with another family member after the elderly owner moves into senior assisted living?
So that the family doesn't start suing each other and never talking to each other when it's all like, oh, well, we just kind of agreed on it. That's why. Like having things written down with clear provisions is the best way to avoid lawsuits in the future. Like, holy cow. This happens way more often than I think probably people even think of it, that if family members are there living at the house and then they're just willy-nilly and what's going on, like, oh yeah, they said I can live here free. And then the other family members are like, what are you talking about? Like, this is a super nice house. You know, it's $1 million house. You've been living there for a year, no rent. What's going on? Yeah, mom and dad said I could. Do you have anything in writing? No, they just said I could. Come on, it's mom and dad. That's why. So if there is going to be any type of somebody's living with someone else, or also these like care contracts, I'm going to move in with mom and dad and I'm going to take care of them. And because I'm taking care of them, I'm not going to pay rent. Well, what are you going to do to take care of them? Does that mean you sit and watch Jeopardy with them for 30 minutes at night? And then the rest of the day you're out doing your thing, partying, all that kind of stuff. What is it? You're going to handle their groceries. You're going to handle the cooking. You're going to handle cleaning, when, all that kind of stuff. And here's how much you're going to be compensated for it. And here's how much the rent is. And you're going to deduct it off of that. Make it clear so that in the future, a year, 2, 5 years from now, people don't go point back and say, oh, I want all my money for caregiving, or, oh, I want all that back rent. And then lawyers get involved and it just gets messy and expensive. So that's why you would want to have it written down so that everybody has clear expectations of what the heck is going on.
Okay.
Something in writing is so good in court. Let me just tell you that. When we go to trial, we can say, here, this is signed, written down on that date. Oh, that's great. Love that evidence. Okay.
Okay.
Sorry.
Okay, so we only have one more question left, and that is, so there's a trust with 2 children, co-successor trustees. One of the children is an out-of-state attorney. And the question is, how does one resolve problems that may come up? Is it wise to hire another attorney to step in?
First of all, your problem was naming an attorney as your trustee. So don't ever do that. All right. No, but I understand it's a child. So when problems come up, is it advisable to get an attorney? Well, I'm going to say it depends on the attorney, right? Good attorneys are going to be able to problem solve and advise a trustee and say, okay, here's your situation. Here's what you should do to get this handled efficiently, effectively, and avoid problems. That's hiring a good attorney when we're dealing with a trust administration is always a good idea. But is it necessary in every circumstance? Maybe not, just depends on the situation. But if we're dealing with problems, then yeah, getting an attorney involved and saying, here's what your rights are, here's what your obligations are. That's what you got to do. Figuring out what is the best thing to do next and getting advice of an attorney is great, because then you're going to sleep at night knowing I'm doing the right thing. That's my experience. But getting the advice of a bad attorney is always a really, really bad idea. It makes problems worse. So just be careful with who you hire. That's what I would say.
Okay. All right. Well, thank you. I think we got to all of them. Thanks to those who stayed till the very end. Hopefully we've answered all of your questions. If not, feel free to reach out for further guidance. So thank you so much to everyone for joining us today. It's been a pleasure. Everyone stay safe, stay healthy, and let us know if we can help in the future.
Thank you, baby. Thank you, Stacey. Bye-bye.
Bye.